Oh. Let's see what's going on. All right, good afternoon, everyone. Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
All right, we're ready to start.
Where's the courtroom? Call them now.
I'm sorry.
Courtroom not on.
Oh, it's not.
What y'all doing? Y'all logging on?
Called technical difficulties.
All right.
Let's
I said,
see.
okay. Yeah, y'all are.
While we're waiting for the jail to come up, Your Honor, we do have a cross warrant case that is going to be position 9, Davida Meconico, and the Challenger Law Group is here on that case. And then the other case is Dennis Jackson, which is position 8 right above it.
Okay. And he doesn't have private counsel.
I believe Miss Gant, I think when she unmuted herself, but I'm not sure. Miss Gant, are you on Dennis Jackson's case?
No, Your Honor. Good afternoon, Ms. Falk. That will be PD Kenzie Johnston.
Okay. Thank you, Miss
Is that
Gant.
a new person for me?
Yes, yes, Kinsey Johnston. I'm representing Mr. Jackson.
All right, nice to meet you.
Nice to meet you too, Judge.
And
All right.
Your Honor, Judge Mincy,
Yes.
I do apologize for interrupting. I
low.
will need a breakout for position 2, Mr. Bradford.
Okay. And that's your case.
Yes, Your Honor.
Which solicitor is on that case?
That is going to be Mr. Segura, I believe, if I'm not incorrect. And I will also need to go into the breakout.
All right, there's Mr. Segura. Okay. All right, I'll go ahead and call the calendar. This is, good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and we are going to begin our Fulton County State Court Expedited Accusations calendar. This is the calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address matters such as bond, possible arraignment, and consideration of any plea offers if one has been given at this juncture by the state. My reset date is
August the 30th.
August the 30th. All right, just want to let everyone know that's the reset date for SAP. I'm going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want to also remind the defendants of certain constitutional rights that they have. The first being that you have a constitutional right to an attorney to represent you at this proceeding, which most of you have already secured, and you have your attorneys available, and you will see them on the screen, as well as you have a constitutional right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrence of your case can and will be held against you, so govern yourselves accordingly. Follow the lead of your attorney and do not make any statements against your interest. All right, the first case that we have, I see courtroom 2 there.
Yes, good afternoon, Judge. This is going to be position 11, Mr. Jai.
All right, this is case number 22 CR 005403B. Myron Najai, you're charged with 1 count of simple battery against a police officer, police dog, or corrections detention officer. That offense date is August the 15th, 2022. Pre-trial, do you have anything?
He got 5 cycles. He been in jail since June of last year for some felony, no bond charges. 2020 disorderly conduct, simple assault dismissed, and 2020 trespass damage to property 2nd degree. And simple assault, he got first offender for that. That's it.
All right. Is this Ms. Johnson's case?
Yes, Judge, it's my case.
Now I'm gonna make sure I get that correct. I have a Johnson and a Johnston, okay?
Oh, okay, that is
Yeah.
confusing. I'm sorry. Well, I am also representing Mr. Najai, but it's Johnston for me.
I got you. Who's, so Ms. Johnson, prosecutor, this is your case?
Yes, Your Honor.
Okay, go ahead. You may proceed first.
Yes, Your Honor. Incident date, August 15th, 2022. Of course, their location is 901 Wright Street. This case occurred when the defendant spat on Officer K. Mike's left arm while he was conducting medication. For this case, Your Honor, we will be asking for a 1,000 surety bond.
Okay. All right. And now Ms. Johnston.
Judge, we would agree with the $1,000 surety bond for Mr. Najai's case.
Okay. All right. I will order the $1,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. And I guess there are no other conditions at this point, correct?
Correct, Your Honor.
Your Honor, may we request no further violent contact with the deputy?
Okay. And no further violent contact with the deputy victim in this case. I'm assuming that can be arranged. I know one time we talked about this in another case, but I'm sure that they will make sure that that happens. This person is still incarcerated.
Your Honor, that's why we're specifying no further violent contact as opposed to no further contact whatsoever, so that if he does have violent contact with this deputy, it will be a violation.
Gotcha. All right. And no,
I apologize.
yes.
I was going to give you the deputy's name. His name is Kenoy Mike, Kenoia, last name Mike.
M-I-K-E
Ke.
is the last name, okay?
Yes, Your Honor.
No further violent contact with Deputy K. Mike.
Yes, Your Honor.
All right. That should conclude this matter. Anything else that I need to take up, counsel?
No, Your Honor.
Your Honor, this is Officer Norris in courtroom 2.
Yes.
Can you repeat that bond amount, please? We have a network issue, so it kind of froze on us, so we didn't hear it.
Oh, I'm sorry. No worries. That's a $1,000 surety bond and no further violent contact with Deputy Mike.
Thank you.
All right, thank you.
Next, we have position 3, Mr. Campbell. This is a private attorney case.
Good afternoon, Your Honor. Brian Tevis for Zachary Campbell.
Yes, hi, Mr. Travis. All right, this is case number 22 CR 005398J. Mr. Zachary Campbell, you're charged with 1 count of simple battery family violence. The offense date is February the 15th, 2022. Pretrial?
9 total. Last arrest was June. Cobb County for simple battery obstruction, simple assault. That's open. On probation in Cobb, ag assault, false imprisonment, simple battery DV. 2017, they gave him 9 years probation for that. Hold on, Judge. 2016. He got a 2010 harassing phone calls, 2 counts conviction. 2010 FTA. And a 2006 hindering person from making emergency call conviction. And the 09 battery DV conviction. That's it.
All right.
Good afternoon, Your Honor.
All right, Mr. Segura.
This case occurred on February the 15th, 2022 at the incident location of 2026 Sumter Street, Northwest Atlanta. In this case, also responded to a call from the victim, a Miss Kayla Morgan. Kayla spelled K-A-Y-L-A, Morgan spelled M-O-R-G-A-N, who said her boyfriend, the defendant, assaulted her. When police came to talk to Ms. Morgan, she stated that she was sleeping when the defendant woke her up by knocking on the door. And when she opened the door, it came out that the defendant was irate and angry because she was not responding to the emails that he sent her. Because of that, the defendant jumped on her, started kick and punch her, then caused her to fall on the ground. When police were able to talk more about it, Ms. Morgan complained about the pain in the area she was hit, mostly in the arms and the legs. And outside, at the time when she was speaking with officers, she stated that it was not the first time the defendant has placed his hands on her. Because of this, the state's recommendation is a $10,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons, and no further contact with Ms. Kayla Morgan. Our recommendations are based on these facts, and we also have special concerns because of the relationship between Ms. Morgan and the defendant. We spoke to Ms. Morgan earlier today, in which they said that both she and the defendant are in a relationship, and that they did not all live in that incident location, but reside together in Cobb County. She stated that she called the police before in Cobb County in June because of a similar incident in which the defendant was arrested. Alongside, she also stated that the defendant has a drinking problem and gets angry when he drinks. Because of this, we are concerned about the safety of Ms. Morgan. Alongside, we are also deeply concerned about this defendant's history. In 2009, he was convicted of family battery violence in Cobb County with a different victim. Alongside, in 2010, in his harassing phone call guilty, when his charges was initially simple assault family violence, but that particular charge was not prosecuted. And alongside, in 2010, he had a probation violation for his battery family violence. So this is concerning because this demonstrates that he will not follow court orders relating to his charges. And alongside, in 2016, which he had 3 counts of simple battery family violence indicted, 2 counts of family battery violence indicted. In this case, upon further investigation, it was dead docketed because the defendant was incarcerated because of the following Cobb County aggravated assault case, in which it stated that it's dead docket until further order of the court. And this case, in which was the reason for this dead docket, was in Cobb County for aggravated assault, simple battery family violence, and 2 counts of battery family violence, in which this defendant, with a different victim, got 9 years of probation. To us, it's very concerning because it does have shown a very long history of family violences for more than over a decade ago, which still continues today and shows no signs of abating. Alongside, this shows the Ando's not the same victim. It does show violence towards people who consider family. And alongside in concern with this particular victim, Ms. Morgan said that she's not fear the defendant and wants to make contact, but it's not a good idea. She stated in the police report and before in the contact that he did lay his hands on her. And alongside, what's very important is that in that June, she did call police on the defendant because of a similar attack. And when I called the DA's office this morning, they said that it is open case as a felony of aggravated violence with Ms. Kayla Morgan as the victim. And we made contact, they said there was a consent bond in which the defendant had a $5,000 bond of some sort, in which he was to be supervised upon released, and he had conditions of no alcohol, drugs, and weapons, no breaking new laws, and also an ADET, and no further contact with any victims in that case. So because of all these major concerns that we have, and especially in regards to the safety of Ms. Morgan, since she said she wants to make contact, but it's based on defendant's history, there seems to be high likelihood, a chance that the defendant will attack her once again, and especially since she said that he does have a drinking problem and gets angry when he drinks. We find that we agree with the surety bond. Thank you, Your Honor.
All right. Do I see the victim on the Zoom?
She is on, Judge, the alleged victim. Kayla, her name is Varnador on here, but that's Miss Morgan.
Okay. Do you want to go before the victim?
Yes, Judge, if I could just respond to what the state said.
Okay.
Obviously, this is a first appearance, so presumption of innocence remains with Mr. Campbell with regard to these charges. I've spoken to Ms. Morgan. I know she's spoken with the state. What is evident from the reports and from speaking with Ms. Morgan is this isn't a violence issue. This is an alcohol substance abuse issue. In between this incident and then being arrested in Cobb County, he was at the Valor House rehabilitation program for 60 days. He had to leave that program. I understand the medication they required him to take was causing problems with his liver or something like that. So he couldn't take the medication. So they terminated him from the program. He already has a program lined up in Marietta. That's at the extension. He's on the wait list. He's waiting for a bed to be available there. We have an address where he's going to go live with another friend on a farm away from Miss Morgan, but I understand that she does want to have contact with him. But there is a plan in place, which is why a bond was reached in Cobb County and why he was released from Cobb to this hold, is to try to get him to the extension so that he can receive the substance abuse treatment that he needs. He's not a violent person. He has an alcohol abuse problem that's gone back for a while, but in between that, when he's had periods of sobriety, he's a productive member of the citizenry. He works, he's employed, he's stable. It's only when he's, has cravings and has gone back into alcohol that his life is disrupted. But as I said, he has a plan for that. He is on a waiting list at the extension in Marietta. Can provide that address. I can also provide the address where he would reside while he's waiting on that bed space, which is not with Miss Morgan. I can either email those to the DA or to the clerk. I don't want to put that out on chat since this is being streamed, but the amount of bond is a barrier. He does not have a lot of funds. He just had to make the bond in Cobb to be able to get transferred to this Fulton hold. And so we are asking if the court would consider either a signature bond to the program or a lower amount of bond. The goal is to get him into the program, which he's also going to have to pay for. So I don't share the state's sentiment that money is the solution to this or that a higher bond is somehow going to ensure that these problems don't exist. What is going to solve those problems and ensure that there are not future violent problems is to treat as substance abuse. And so with that program being lined up, I would ask that the court set a lower bond or a signature bond so that he can remain with his friend. And then the bond condition can be that once a bed is available at the extension, he goes straight there within 24 hours or whenever they'll intake him. And that is a better route to ensuring this doesn't occur than just setting a high monetary bond that he can't make. But Ms. Morgan is on and she can address any of the other issues that the court may have concerns about.
Okay. All right, Miss Morgan, Kayla Morgan, can you unmute yourself, please? Do you wish to address the court today?
Yes, I do.
All right, raise your right hand for me. I'm going to swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right, you put your hand down. What would you like to tell me briefly about this incident?
Regarding this incident, it was obviously the first time it had happened. Zachary's not a violent person. He's not a bad person. Everybody that knows him loves him to death. He is a hardworking man. He provides for me and my daughter, who is not even biologically his. And he's been more of a father than anybody to her. The entire 60 days he's been in Cobb County, he's called every day to make sure that she's okay and she's doing her homework and being a father over the phone and being there for her. He loves us and we love him. He does have a drinking problem, and that's something that we want to address by him going to a program instead of sitting in a prison cell and not getting help. That's not going to solve anything.
All right, are you in fear of Mr. Campbell?
I am not, no.
All right, any cross-examination, Mr. Segura?
I would. Ms. Morgan, back in June, didn't you call the police in Cobb County for a similar incident such as this?
It was similar, as in he was intoxicated and trying to get in the door.
But at the same time, he was arrested, and wasn't he?
I'm sorry?
But he was arrested for that and similar incident.
Well, he was arrested because of the warrant for Fulton, and then they put on the charge of battery because it scared me when he kicked in the door. He's a lot bigger than me, so it's gonna be, a little scary, but I didn't know how to handle the situation, and so that was the only thing I knew to do. But I wasn't scared that he was gonna hurt us. I just didn't want him to hurt himself or anything like that. I didn't know what was gonna happen, so I felt like that was the best way to control the situation.
In the warrant that is from Fulton from February, it states that you told the officer that he did place his hands on you before. So what was that about?
I'm not sure. I had actually started a new medication and was asleep because of that medication the night that happened. So I'm extremely fuzzy on what I said or what actually happened, because the dosage that I was at was a low dosage that makes me dream while I'm awake. So I could have dreamt certain things happened or imagined it happened, and I can't tell the difference between what happened and what didn't. So, as far as what I said, but I don't believe that he hit me. If I said that, I don't believe he did at all. I know that it scared me, him coming in the door. He was upset and he left and I was crying, and that's about all I remember. But I didn't have any marks or bruises or, sore spots or anything like that. So he didn't kick me or hit me or anything like that.
But didn't you also complain and tell the officer that you had injuries to the areas he supposedly hit you on your arm and leg?
I don't remember that at all. I remember my side hurting, but I have pleurisy that comes and goes. And I had been smoking a lot recently and hyperventilating and crying because of the situation. So my side was hurting. But that wasn't because he hit me. That was my pleurisy flaring up.
I see. Thank you for talking to me. That'd be all on my end, Your Honor.
All right, Mr. Tavis. You're on mute. Still on mute.
I just had one follow-up question. This incident in Cobb, Ms. Morgan, when I spoke to you back in June about that case, you said that there was damage to the door, but that he did not have any physical contact with you. Isn't that correct?
Correct. He just came through the door and went to bed.
Okay. And in between these incidents, he was at the Valor House for 60 days. Is that right?
Yes.
Okay. And that's a sobriety program.
Yes.
And only because he had to leave that program due to medical issues, were you guys back in the position of living together in Cobb? Is that accurate?
They actually felt that because we're not really sure why, it wasn't really explained, but because he was seeing me during the day, that it was a violation of the contract. They didn't really explain how. And so they did request that he leave. He begged them to stay. We wanted him to stay in the program. And then he came to my house, stayed for 60 days before he came off the medication and had the withdrawals from the medication.
Okay. And you have not seen him since then because he was in Cobb County Jail for 60 days. Is that right?
Correct.
Okay. And you're also the person who's facilitated setting up his acceptance into the extension?
Yes.
Okay. And you can verify for the court, as you're under oath, that he's on the waiting list for that program and is waiting for bed space available. Is that right?
Correct.
Okay. And that's what you would like the court to release him on bond to the program?
Correct. Yes, that's what he needs. I was a corrections officer, and the prison is not going to help him. He needs to go to his program.
All right. Thank you. That's all I have, Judge.
All right.
Your Honor, before I end, I must point out that this is both a substance abuse issue and a violence issue. Based on bond hearings, it's based on a lot of factors. Especially concerned here is the intimidating the victim, who is Ms. Morgan, and the relationship she has with the defendant, and the risk of reoffense, which based on the defendant's history and the facts, alleged facts, both in this case and June's case, makes it high. And thus, we feel sorry that for a surety bond. Thank you.
All right. All right, I'm going to go ahead and give my ruling. I'm going to order a $5,000 surety bond. I'm going to order Mr. Campbell to stay away from the residence, which I think he's already planned to do that. And I wrote down 2026, but I did not write down the street name.
Apparently, both the victim and moved away from this address, so I don't think we need to stay away from this location.
That's correct. Then neither of them reside there anymore.
Okay, so we won't worry about the stay away. Right now, I am going to order no further contact with the victim so that will help both of them, especially the defendant with this new program. So right now, while on bond, no further contact with the victim, Kayla Morgan. No drugs, alcohol, or weapons while on bond, except for those prescribed to him. And I'm not going to order the ADET because he's getting into a program, so that should handle that. But he is ordered to complete and participate in any drug rehab programs, or alcohol rather rehab programs that he has signed up for. I won't name it specifically, but just again to complete any programs that he is in.
Judge, may I ask for a caveat to the no contact? Could they have contact by phone? As Ms. Morgan said, he is a father figure to her daughter. As long as they don't physically get together, could they at least speak on the phone?
I see Ms. Falk coming on.
Yes, the state's concern, and we need to look at the bond out of Cobb County, is that there's a no further contact provision in Cobb County. What your honor orders will then contradict the order out of another county. So it sets them up to essentially be revoked by another county for violating their bond conditions, which, just to be clear, we would ask for it to be revoked. So rather than to get into that situation, I think it's best to just maintain the no further contact.
I'm sorry, I don't know who Ms. Falk is. Are you victim advocate maybe?
No, she is the deputy assistant solicitor.
Okay. Well, then I would ask to only argue against one member of the state. That's kind of the decorum of how court goes. But I wasn't at the Cobb hearing. Ms. Morgan was. She's shaking her head no as to the no contact. So, of course, if he has a court order from either place, we would not violate that. And I can take that up with Cobb if we have to. But for the purposes of this hearing, I would just ask that they be allowed to have phone contact because they kind of co-parent Ms. Morgan's daughter.
May I speak, Your Honor?
Briefly.
The no contact order was against the was it the lieutenant, I believe, or the sergeant? I'm sorry. We have a no violent contact order.
Well, I have, if you have a no violent contact out of Cobb and I've given a no further contact, mine is a little stronger to make sure again that he completes whatever program he's in without any contact or interference on your part. It may or may not be positive for him in trying to complete the program. I understand he is a father figure to your child, but how old is your child?
She's 8.
8. And so she's a minor. And right now we're trying to make sure that Mr. Campbell completes his program sufficiently. And you would have to facilitate those calls unless she has her own phone and he's calling her directly. So again, we don't want him to be in trouble or violate these other bond conditions because he has to obviously contact you to contact your daughter, right?
Yes, but we have, like I said, we have a no violent contact, so we're allowed to have contact. It's just we can't have violent contact, or he is in violation of Cobb County.
Well, I also know this incident happened in February. Is that correct?
Yes.
Okay. Well, what I'll do is as long as it does not contradict, and I don't have the Cobb County bond order in front of me, I'll do the no further violent. But again, if it contradicts any other orders, you need to go to, go by the stronger order, obviously, of no contact. And I know that sounds confusing, but I'll do no further violent contact on this one as well, if that is coinciding with what's in Cobb County. All right.
Thank you, Your Honor.
All right. Thank you, Your Honor.
That should conclude the ruling.
Thank you.
Uh-huh.
And if I could confirm, I didn't catch the case number. It cut out earlier. Was it
Oh,
22 CR?
005398J.
Thank you so much. We'll file an entry on that. Thank
Your
you.
Honor, would it be okay if we retain the no further contact until we confirm with Cobb County that it is in fact no further violent contact?
And I'm working on confirming that now, Your Honor.
Okay. Let's.
Well, I mean, in any event, if she has if there's an order from Cobb saying no contact, then she can't have contact. My concern is if we try to do this here, then we'll have to do another modification depending there. But as the court said, whichever one is controlling is going to be controlling. Otherwise, there'll be an aggravated stalking. So,
Well, yeah, I certainly, and as I stated to Ms. Morgan, that you are to go by the higher order, meaning if one says no contact and one says no further violent, you would go by the no contact. But I don't certainly want this to be confusing or contradictory so that the defendant, is incarcerated or gets another charge, as well as putting yourself and your daughter in jeopardy as well. Can I hold for a few seconds? I believe that Deputy Falk is pulling up that Cobb order. It should be able to be received. If you could hold for a few minutes, Mr. Tevis, I'm going to go to my next case and let me come back because I don't want it to be confusing for anyone if my order contradicts, another jurisdiction.
I'll just be in the background whenever the
Okay.
court wants to take the matter.
All right, thank you for waiting.
Sure. Thank you.
Let's hold Mr. Segura. Let's go to the next case and let's see what we do.
Judge, the total bond was 5,000, correct? Good bond, 5,000?
Bond is 5,000 surety, yes. And we'll hold on those conditions.
Okay. Position 15, Mr. Smith is next.
All right. Where are we with the case that has the attorney 8 and 9? Is it possible? I know you have a certain order.
Repeat that again, Judge.
We have positions 8 and 9. I have an attorney on 9, I believe.
Yes, also 9, you said, has a private attorney? You have a private attorney? That's conflict.
No, position 9, isn't that the Challenger Law Group?
Yes, ma'am.
You all are not conflict attorneys, correct?
No, ma'am. Attorney Challenger is a private attorney, but this is the conflict case that she's taking over.
Okay, she's taking over. Yeah, 9 is a private attorney now. The Challenger Law Group taking over from the conflict defender.
No, ma'am. I'm sorry. I might have confuse you. So she is a private attorney, but it's a conflict case. Like
Oh, it
she is taking the conflict case.
Gotcha. Okay, I did say that wrong. I apologize.
Yeah, they'll be going next, Judge. We just have a visitor for position 15. That's why they're going now. The mother is here.
All right, thank you, Deputy. All right, position 15, 22 CR 005407G, Brian Keith Smith. You're charged with 1 count of battery family violence. The offense date is August the 9th, 2022.
First arrest.
All right,
Good afternoon, Your Honor. Good to see you again. This is Lee Reed
yes,
for
I'm
the
sorry.
state.
I was looking. Okay, all right, this is ASG Reed. Yes.
Okay, for this case, the date of the offense was August 9th, 2022, and the location was 728 Marsh Trail Circle Northeast, Sandy Springs. The defendant and the victim, a Vonquise Sab, and I'll spell the first name, that's VONQUESE, last name spelled SABB. These two live together and they're in a relationship, and they do not have children. An officer was dispatched to the incident location, and he was met with Ms. Sab, who was crying, trembling, and had a shaky voice. Ms. Sab told the officer that the defendant choked her after an argument, punched her in the back of the neck and in the right side of the rib. The officer did observe a visible injury and a fresh scratch mark on her neck. The defendant had left the scene prior to the officer's arrival, but he was arrested later on August 15th, 2022. I understand Ms. Sab may be on Zoom, and she told our office that she does not wish to speak. She said the defendant currently is back in the house and they're living together since the incident. And she said this has never happened before. However, even though the defendant has never been arrested and this is his first offense, the state's position is we typically ask for a stay away and no further contact because otherwise defendants will likely to influence Ms. Sab not to press charges in the future. And Your Honor, if you are inclined to give the defendant a signature bond with the only conditions of no further violent contact, the state would request an 8-week anger management course to be a condition of that bond. So for this case, there is no bond, and we're asking for a $3,000 surety bond, no further contact with the victim, a stay away, no drugs, alcohol, or weapons while out on bond. And with the surety bond, we would request a 1-day anger awareness class. Thank you.
All right. And this is Ms. Johnson's case?
Yes, Judge. As was previously stated, Mr. Smith does not have any criminal history. It's my understanding that he does not live with the alleged victim in this case. He lives with his mom at the 4919 Heritage Crossing Drive Southwest address. And that is where he would be going if he was released. Again, he doesn't have any criminal history, and the paperwork that I saw showed that he does qualify for unsecured judicial release. We would be asking for that, or in the alternative, a signature bond. And we would ask for no 8-week anger management course, as he has not been convicted of any crime yet.
Okay.
And Your Honor, I understand the victim is on, but she does not wish to speak.
Okay.
Thank you.
All right. And Ms. Johnston, what kind of work does Mr. Smith do? Or does he have a job?
He's currently unemployed.
He was recommended.
All right, thank you. I'm going to give a $4,000 signature bond through pretrial. And I am going to order a stay away from the 728 March Trail Circle Northeast in Sandy Springs. I'm going to order no further contact with the victim, Ms. Voorhees Saab. No drugs, alcohol, or weapons while on bond. And for now, I'll do the 1-day anger awareness course. And that would be the ruling of the court, $4,000 signature bond through pretrial. Anything
Thank
take up
thank
counsel?
you, Your Honor.
All right, thank you.
Position 9. All right.
Hello, Your Honor. My name is, I'm sorry, go ahead.
I think you can go ahead. Wait, hold on a second. I think Ms. Falk is gonna give us the information we need on the other case. Hold for a second.
Your Honor, I did get off the phone with Cobb County. I asked them to read the condition verbatim and have typed this out verbatim from what they put in the conditions.
And
So
let
the
me-
condition reads as follows. Defendant shall have no contact of any form, either direct or indirect, with any victim or witness in the case, to include no contact with the witness/victim's residence, workplace, and or school. Additionally, the defendant is to have no contact with the following individual: Sergeant C.J. Denson. As Ms. Morgan is a victim of the simple assault charge, she is included in the victim provision that was part of the stay away order.
Mr. Tevis.
Judge, I'm looking at the Cobb docket where that's typed. Cobb does not have, for state court, they do not have like an ability to open or download the actual order. So I'm seeing that language on the docket entry, but it's not a copy of the order. I would just reiterate what I said before. Ms. Morgan was at the hearing. She's texting me that that was not what was said in open court and that he had a copy of the paperwork. So I would just ask if this court set it as a no violent contact or phone contact only. If we get a copy of the order from Cobb and that's controlling, then of course he will have to abide by that. But I don't know, in case that's not correct, I don't know that it is going to make a difference to put it in two places and then have to fix it here if that's not correct. So I would just ask, Ms. Morgan's online. She wants to have contact. I would say even phone contact so they can still talk to her daughter and have phone contact with her. Certainly, whatever concerns the state has, they're going to be separated physically. The order can be don't discuss the case or something like that. But I think that they should be able to have phone contact. And if the Cobb order, when we get a copy of it, is more strict, then that is the controlling order. I don't think that it's warranted to put it in two places. It's just going to overly complicate the issue. And that's all I can say without a copy of the order in hand.
And Your Honor, what will overly complicate this issue is having two contradictory orders. That is why the state is making this request. As an officer of the court, I have spoken to Cobb County. I've gotten the information from them. I read it back to them to make sure the information was correct that they were providing me. All I can do is provide that information to the court in my place as an officer of the court, that I am stating that this is the information that Cobb County has provided for me.
Right. I am surprised with the victim that she doesn't have a copy of that, but I tend to agree with the state. If it's on the docket and we just don't have a copy of the actual order, I would not want to give a contradictory ruling at the moment, and then you can always apply to modify the bond conditions. I am going to order no further contact. I'm not going to go with just phone contact or things of that nature, because I don't want to have the situation of, and we have it a lot with contradictory orders from different counties and all. It just usually bottlenecks into a worse situation later. And then when the defendant's in jail, he doesn't know which way he's supposed to go or not go. And I think that it would help him possibly get through these programs that he needs to focus on at the moment. So I'm going to do no further contact unless we find out different. And then Mr. Tevis, you can apply for a modification of it, file a motion, and it can be brought back or reconsidered. But I want to kind of stay in line with Cobb County to not aggravate or complicate or confuse the situation any more than it already is, okay? And I do understand, Miss Morgan, what your position is. I understand about your daughter, but again, we want to make sure that Campbell is getting what he needs to better himself, and then hopefully once he's off bond, in both of these cases, something can be worked out for the reunification of you all, okay? So I'm going to do again, it's a $5,000 surety bond, no further contact with the victim, Kayla Morgan, or her daughter, and no drugs, alcohol, or weapons while on bond. And I think that is it, and that he must complete and participate in any alcohol or rehab programs that he is a part of. So that will be the ruling of the court, okay? And thank you, Ms. Falk, and thank you, Mr. Travis, for that information. All right, that will be the ruling.
Judge, that concludes my matters before the court, if I could be excused.
Yes, you may. Thank you.
Thank you.
Excuse me, Your Honor.
Yes.
It's my understanding that we're about to do position 9. I just asked that we do position 8 at the same time.
Okay. Let me do 9, 9 and then 8. I think the deputy has 9 before me. This is Ms. Davida Panasico. Say that again? Mechanical, I'm sorry. This is 22 CR 005402A. You're charged with 1 count of criminal trespass and damage to property. The offense date is August the 15th, 2022. Pre-trial?
Fourth arrest, 2020 shoplifting, 2020 simple battery, 2021 probation, shoplifting. That's it.
All right. And Ms. Johnson?
Yes, Your Honor. I have the date of offense as August 8, 2022, with the incident location being 714 Home Street, Northwest Atlanta. The victim in this case is Dennis Jackson. Dennis, common spelling, but I will spell it for you, Your Honor, Dennis, last name Jackson. Your Honor, this case already has a preset bond for 1,000 surety. I will be asking for that bond, but I will recitate the facts for the case, Your Honor. Ms. McConaughey stated to officers that the defendant threw a rock at her vehicle, causing a dent and a scratch. Ms. McConaughey and Mr. Jackson, who's the co-defendant in this case, share a child. McConaughey was dropping the child off at Mr. Jackson's residence when they got into a verbal dispute. When officers spoke to Mr. Jackson, he informed that McConaughey and him were arguing, and she damaged his spring door and messed up his house. Both parties were then arrested. In this case, Your Honor, I will be asking for a 1,000 surety bond, a stay away from the incident location, and no further contact. I would be okay with the third-party transfer of the child, because it's my understanding they do have a child together. Your Honor, it should be okay to have a no further contact from the incident address. It's my understanding that it's Mr. Dennis Jackson's home.
All right. And now the Challenger Law Group, and I apologize for not knowing your specific name.
So my name is Maya Fuqua, and I am an intern here at Challenger Law Group, and I am practicing under the 3rd Year Practice Act. And if it is okay with you, I would like to proceed on behalf of Attorney Challenger.
Hold on 1 second, Ms. Falk.
Yes, Your Honor.
I know you're a little familiar with the 3rd year practice. Are they allowed to practice by themselves, or do they have to have the direct supervision of the?
I believe she has someone in there with her, hopefully.
Yes, ma'am,
Yes,
I do. I'm sorry.
If she has direct supervision, she may practice.
Good afternoon, everyone. Good afternoon, Your Honor.
Good
Judge
afternoon.
McPhee, Ms. Falk.
Good to see you. I was just making sure.
Likewise.
She's alone. I think that she can't be, but it's good to see you, Attorney Challenger.
You as well. No, she's not alone. I'm here in the background. She is going to take over this bond hearing, but I will be supervising.
Thank you. Just making sure. I appreciate
Thank
it.
you. All right.
All right. Not to embarrass you at all, Miss. Is it?
Oh, no, I'm fine. Thank you, though.
Yeah, is it?
Ma'am.
Your last name is Fuqua?
Yes, ma'am.
Okay. All right. Go ahead. You may proceed.
So we are asking for a signature bond on behalf of Ms. Davida. She is the sole provider for her 3-year-old son, who is currently in the care of her mother. This is not long-term care, simply because her mother lives in Alabama and she drove to Georgia for this certain circumstance. Ms. DeVita also is full-time at DHL, where she currently works and has been for the past few months. And she's been a resident of Georgia for the last decade. And in asking for the signature bond, we think that it is in the best interest of Ms. DeVita and her son because she is that sole care provider, and that $1,000 would be a little unattainable. We would also, I know that Ms. Falk mentioned a contact order, but we would ask for it to be a no further violent contact instead of a no contact order.
All right. And you said the child was 3 years old?
Yes, ma'am, and is currently in the care of the mom until the circumstance resides with Ms. DeVita.
Okay.
And for Your Honor's information, that child was present during this exchange.
Okay. And so there's already a $1,000 surety bond, is that correct?
That's correct, Your Honor. And Your Honor, for the record, I would object to no further violent contact. This incident did happen yesterday on August 15th. There hasn't been a sufficient cooling off time. They both had actions against each other. The officer decided to arrest both of them. I'm concerned of there being no cooling off period.
Right. All right. What I'm going to do in this case is I'm going to order a $2,000 signature bond through pretrial per judge. And I'm going to order the 1-day anger awareness course. I'm going to order a stay away from the 714, was it Cone Street? Southwest? Is that the address? For
I'm sorry, I have two different addresses for some reason, excuse me. Let me double check the warrant because I do
have on the accusation.
Let me go back here and I apologize. I'm looking at a 714 Home Street Northwest, but I want to
That's what I'm
confirm.
showing.
And you're muted, Ms. Fuqua. What do you have?
I don't have his address, so we have a different address.
You have a different.
What Ms. Johnson was speaking of, yes, ma'am.
Ms. Bridgewater, what do we have on the accusation?
Let me pull it back up. I thought I saw the Holmes address, but let me just be accurate with it. Let me pull it up. In just a second.
Okay.
I have the incident address, what I recitated earlier, which was 5 Livermore Street. But I'm not exactly sure why it would be different on both of the warrants.
Ms. Fuqua, can we ask your client which address she's aware of that Mr. Dennis Jackson lives at?
Yes, ma'am.
All right. Ms. McConico? I think the jail has you muted. Okay. Do you know which address Mr. Jackson resides at?
It's the one you have on file, right? 714.
Okay. Was that the incident location or that's just his residence location?
The incident location.
Okay, 714 Holmes Street Southwest. Is that HONE or HOME?
Oh, yes, I wasn't sure his address, whatever address they put on the file.
I saw the incident location is the Livermore.
That's what I have on the warrant, Your Honor. I have 5 Livermore.
And so the incident occurred at the 5 Livermore?
Livermore.
That's what I have. I mean, it seems like the defendant may have something different. I would like to confirm, but my warrants do say 5 Livermore Street Southeast.
Okay. Ms. Monaco, did the incident occur at the 5 Livermore Street?
Yes, ma'am.
Okay, and do you know that's where Mr. Jackson resides or not?
Yes, ma'am.
He does or doesn't reside on Livermore?
Yes, he be there when I drop my child off. That's what he resides at.
Okay, that's where you dropped your child off. That's where the incident occurred on Livermore. Okay. And so we'll use that as our stay away address.
And can I ask a question? Whenever you get a chance?
Not sure. You may want to consult with the attorney. It depends on, you're asking me about the bond conditions, but I don't want to hear anything, or you shouldn't make statements regarding the facts of the case. You have a question about the bond conditions?
What Ms. Johnson mentioned, she said that we got arrested for being violent towards each other, but it was a damage to the property. We didn't put our hands on each other.
All right.
For the correction of the street, just to make sure we have it on the correct, and I have Livermore, Livermore.
That's
Okay.
what I have.
And I think I was pronouncing that totally
Right.
incorrect. So I apologize for that.
Mhm.
All right, Livermore Street. So I'm going to rule that there will be a $2,000 signature bond through pretrial per judge. I'm going to order you to take a one-day anger awareness course, Ms. McConaughey, but I'm going to order you to stay away from that 5 Livermore address. And you are to have no further contact with Mr. Dennis Jackson, no contact with him. If there is visitation allowed with your child, then that must be conducted by a third party transfer by another person, so that he and yourself are not in company or around each other at all. So if it is your mom or a friend or someone else that would do the exchanges with the child, not the two of you, is that clear?
Okay, say it again. Yes.
Okay, all right, and that one-day anger awareness course pretrial will tell you about that. There's to be no drugs, alcohol, or weapons while on bond, except for any prescriptions prescribed to you. All right, is there anything else council need to take up?
No, Your Honor.
Okay, anything else, Ms. Fuqua?
No, ma'am. May I be excused?
Yes, ma'am, and you did an excellent job.
Thank you.
You're welcome.
You're on mute. You have a question? No, I said.
All right,
Is Mr. Jackson in the court, Your Honor?
I'm sorry.
Is Mr. Jackson in the court? It was my understanding.
Yeah, I'm trying to figure out who's there.
This is position 8, Jackson.
Okay. Oh, that was not him. Okay. All right, this is 22 CR 005401J, Dennis Jackson. You're charged with 1 count of criminal trespass and damage to property, offense date August 15, 2022, pre-trial.
Third adult arrest. He's on probation for selling marijuana and driving without a valid license. And he has a Clayton County hold. That's it.
All right. Ms. Johnson?
Excuse me, I wasn't selling marijuana.
Hold on. Do not speak. It is not your time to speak. All right, Ms. Johnson?
Yes, Your Honor. He already has a $1,000 set bond as well. I'll be asking for the same bond, no further contact, no alcohol, drugs, or weapons, and a third party, transfer for the child. Is Your Honor satisfied with the earlier recitation of facts?
Yes.
Thank you, Your Honor.
Remember that. Thank you. All right, and Ms. Johnston?
Yes, Judge. We would be asking for a $1,000 signature bond on this case. Mr. Jackson is not employed and does not have a means of paying his bond right now. He has lived in Atlanta his whole life. And that is everything from defense, Your Honor.
All right, he has a Clayton County hold. Are you aware of that, Ms. Johnston?
Yes, Judge.
All right, so with Mr. Jackson, he's going to be going to Clayton County, is that correct?
I would assume so, Judge, but I'm not sure what the protocol is for transferring people to Clayton County right now.
Well, what I'm going to do is I'm going to order that $1,000 signature bond through the jail. I'm going to order no further contact with the victim or with the co-defendant, rather, I'm sorry. Ms. Davida McConicle, you'd have no further contact with her. If there is a exchange or visitation with the child, that it be through a third party. And you are to stay away from her location where she resides. No drugs, alcohol, or weapons while on bond, except for any prescriptions that are prescribed to you. And counsel, is there anything else I need to take up?
Judge, I just asked that he can return one time with law enforcement to retrieve any belongings he has.
All right, and you can have a one-time law enforcement escort to return to the property to retrieve any personal belongings. Mr. Jackson, do not go there by yourself, as you can be rearrested, but you will need to arrange with law enforcement to escort you to that property if there are any personal belongings that you need to get if and when you are released, because I think my understanding is that you will be going to Clayton County first. All right. And I think that should conclude everything. Anything else, counsel?
Nothing
No,
further.
Judge.
All right. All right, Mr. Tavis.
Yes, Judge. Thank you. I contacted the magistrate court clerk in Cobb County and have obtained a copy of it. I don't see, oh, maybe I can share my screen if that'll work for the court. Oh, it's disabled. I can email it, but it does state no violent contact for Kayla.
Can you email that to Holly.Bridgewater?
And
sure
can you email that to the state as well? And Your Honor, I apologize if
Absolutely.
there were any misstatements. This was the information I was being provided by the DA's office in Cobb.
Yeah, I understand.
Holly.Bridgewater.
Holly.Bridgewater at fultoncountyga.gov.
That's correct.
And I'm Shelley.Falk.
It's saying at fultoncountyga.gov.
I'll send that over.
And I put it in the chat as well.
Okay, thank you.
So let me take a quick look. We are finished with Mr. Jackson. Is that correct?
That is correct, Your Honor.
Deputy, we're finished with Mr. Jackson. Let me take this matter back up.
Judge, can we go back to position 15, Mr. Smith?
Yes.
He's choosing not to,
No,
okay, go ahead.
I was just supposed to do a regular bond or like pay the bond money instead of a signature bond.
You want to do what again?
Pay the bond money instead of a signature bond.
Ooh, you're represented by Ms. Johnston.
Yes, Judge. Mr. Smith, I would not advise that. I'm not sure what the reasons are there. We did discuss this on the phone before the hearing, and I thought we were on the same page about the signature bond.
Oh yeah, it's just my mother's advice. And when I came in the intake, I signed the form to like do a regular bond. That's all I was just trying to do.
So you don't want a signature bond?
I just want to pay like the bond instead of a signature bond. Yes, ma'am.
Is he requesting a cash bond?
That's all. I'm not
He's
sure.
requesting a good bond. He don't want to be supervised, so he just want to pay his bond. So just change it from a signature bond to a good bond. That's all.
Excuse me,
Find out. That's what he's saying.
I signed the paperwork for that in intake. It was already supposed to be like that, that's all.
Okay. Ms. Johnston, the weirdest request I've received in a while.
It just happened before, Judge.
It has.
Oh, it happened a whole bunch of times. Yeah, some people just want to bond out.
well, Your Honor, if I may, even
For me. Yes, you read, what would you like to say?
I was going to say, even with the surety bond, we still want the same conditions of the stay away, no further contact, no drugs, alcohols, or weapons, and the 1-day anger management course.
Yeah, I would not change any conditions, but if you would like me, Mr. Smith, to change this to a $4,000 surety bond, I'm certainly happy to do that.
Now, if it's gonna be the same requirement, I'll do the signature bond then. That's not how they explained it to me.
Do you need to go on a breakout and speak to your attorney? Because I'm about ready to just make it a surety bond. I'm not gonna go back and forth with you. You came on and asked that it be a surety bond, and I'm going to make it a surety bond. I am not gonna go back to a signature bond. I'm not gonna go back. That's not how this process goes at all.
When I left
Keep your mask up. Keep your mask up.
when I just left, they explained it to me differently, but all right.
Well, I don't know who the they is, but your attorney is the one that can explain it to you the best. And I can tell you, if it's a supervision issue and you don't want to be supervised by pretrial to receive a signature bond with no money, then I'm fine to change it to a surety bond, and you can put up your money to the bonding company and do that.
Oh, no, I'll go ahead and do it the same way you had it first. I'm sorry about that. I was just misinformed. You all had the best, the best plan.
Judge, I do apologize on behalf of Mr. Smith. I would just ask that we keep the bond as is.
All right, I'm going to leave it as a $4,000 signature bond through pretrial. And so if you don't do the conditions that they tell you and are not supervised in checking in with pretrial as they require, then your bond will be revoked. Are you aware of that? You got about 2 seconds.
Well, hold on. First of all, we're gonna take like 2 seconds.
Who's next?
All right, I will leave it as.
Miss Ray.
And Your Honor, while they're bringing this defendant up, I have had an opportunity to review the bond conditions, and Mr. Tevis is correct. It is a no further violent contact with the victim in this case. So the state obviously does still have some concerns. However, there is a no violent contact order in Cobb County.
All right, so I'm going back to position 3. Zachary Campbell, is that correct?
No, Judge, this is position 13.
Yeah, I didn't need him to come back. I didn't need him to come back. I think, is he already gone?
Yes, he's already gone out the court.
Fine, we will correct. I've got his counsel here, Mr. Tab, and hold for a second. And I'm going to change that, Ms. Bridgewater, on position 3 to no further violent contact.
Also, I forwarded you a copy of that order so you can see it. Okay.
Judge, is there any way that's,
No further violent contact, I will change it.
All right.
thank you. Can somebody at the jail make sure that he gets a copy of it? Because otherwise he's gonna.
Been filed or sent over yet. So we do it at the end of the calendar. So it'll be correct when it's sent over because it hasn't been sent yet.
I mean, for them to let Mr. Campbell know, because the last impression he has is that he can't have contact.
I'm not for sure what the jail policy is on that.
So can pretrial be the one to relay that information to him since he has to meet with him anyway?
No,
good bond. So, no.
That's a good bond. It's not pretrial. He'll just have to read it. I mean, she'll tell him, I'm sure, when he gets out. I don't know that they give them a copy or not. I'm not 100% sure. So you have to-
I'll let him know if not, then. Thank you.
Yeah, that'll be your responsibility to let him
Yes,
know.
Judge. All right, thank you.
Thank you. Oh, no,
Yes, Your Honor, I'm sorry.
nothing. I thought you were going to say something.
No, Your Honor.
Okay, thank you.
Thank you.
All right.
Judge,
right.
whenever you're ready, this is position number 13, Ms. Ray.
Okay. I am not going back to any other cases today.
Thank you.
Okay, you're welcome. Thank you.
My apologies, Your Honor.
It's okay. I mean, we want to get it correct, and I don't, want anyone confused when they leave here. So thank you all for. And
I'm
don't,
confused, Phil.
yeah, I know, right? All right, we are position 13, 22 CR 005405F. Keisha Ray, you're charged at 1 count of battery. The offense date is August the 15th, 2022.
This is her third arrest.
Okay.
Last was 2017. She was arrested, fugitive from justice. It was later dismissed. 13 conviction for possession of a forged instrument, 2nd degree. Petty larceny out of New York. That's it.
All right. All right, Miss ASG Reed.
Thank you, Your Honor. This offense date occurred on August 15th, 2022 at the Atlanta Medical Center. Address is 340 Boulevard Northeast in Atlanta. An officer was called to the scene of the incident because a fight was in progress. Nurse Patterson, who is the victim, her first name is Leah, L-E-I-A, and the last name is Patterson, P-A-T-T-E-R-S-O-N. Nurse Patterson heard the defendant call for help, so she went into her room. The defendant had fallen out of the bed, and Nurse Patterson went in to try to help her back into bed. Now, during this exchange, the defendant was combative and proceeded to kick Nurse Patterson in the stomach and hit her. Nurse Patterson spoke with our office, and she said the defendant was having a fake seizure and was spitting on Nurse Patterson, and further that the defendant was yelling, "I'm going to beat your ass." During the investigation, the officer observed scratches on Nurse Patterson's arms, and they were still bleeding. Nurse Patterson tended to her injuries at the medical center. Now, per the incident report, the defendant was given her discharge papers because of the incident, and the doctors indicated that this type of seizure that she was having was one they could not assist her with. Nurse Patterson told our office that she's concerned with a growing number of assaults, and she may be on the Zoom call. I just also really want to make clear for the record that the state's biggest concern here, Judge, is that this attack was on a healthcare worker who was only trying to do her job. And this is during a time when we have a shortage of healthcare workers and an increased number of people relying on their medical assistants. Nurse Patterson told our office that the violence against healthcare workers has been steadily increasing, and she feels that the judicial system has failed by allowing defendants to get away with assaulting them and being immediately released back on the streets. Now, my understanding is that she does work nights, but she may be on the Zoom call today. The defendant, in terms of her bond request, or our bond request for the defendant, she does not have strong ties to the community, and she is a multi-state offender. And although this is her first violent offense, she was charged in Clayton County and was a fugitive for a fugitive arrest that was in New York City. So for those reasons, we are asking for a surety bond of $7,500, no further contact, a stay away from the location, no drugs or alcohol while out on bond, and a one-day anger awareness class. Thank you.
Okay. Right, Ms. Johnston.
Judge, this case was a situation of Miss Ray having an active seizure and waking up to a nurse on top of her and not knowing what was going on and not knowing what it was she was supposed to do. In the state's own words just now, the doctors acknowledged that she was indeed having a seizure at the time of this event. I agree that healthcare workers are important, but I also agree that a $7,500 surety bond is not something that Miss Ray would be able to afford. I received an email that she does qualify for a signature bond through pretrial release. We would be asking for that today. She works at a CSM company at the airport. She will be able to go back to that job upon release. I do have updated contact and address information. She will appear for all further court dates. And again, I want to point out that she was having a health emergency, and that, you know, when people are having a seizure and wake up and someone is on top of them, even though it is sad that it was a nurse, and it is unfortunate, cognitive awareness was not there. And I also want to point out that today's hearing is not to determine her guilt of the situation. It's just to determine her bond.
And Judge, if I may, I hope I didn't misspeak, but I was saying that she was accused of having a fake seizure. They're not saying she had a seizure, that they did actually discharged her because they felt like her medical condition was something they couldn't even fix. So I just want to make that clear for the record.
Okay. All right, I'm going to order a $5,000 surety bond through pretrial. I'm going to order
5,000 signature.
I'm sorry, 5,000 signature bond through pretrial, yes. And I'm going to order the one-day anger awareness course. I'm going to order a stay away from the Atlanta Medical Center unless she's receiving treatment, obviously from a different nurse. No further contact with this Leah Patterson. And I'm assuming the hospital will make sure of that as best they can. But she shouldn't be at Atlanta Medical Center unless that's the only place that she can receive treatment. No drugs, alcohol, or weapons while on bond. And I think that would be it. Anything?
Nothing further. Thank you, Your Honor.
All right, Ms. Johnston.
Nothing further.
All right, thank you.
I'm sorry, Judge, I was muted. Position 12, Ms. Oka.
This is 22 CR 005404G. Looks like Oka, and I think that may be Chinery or Shinery.
Good afternoon, Your Honor. My name is pronounced Oko. The H is silent.
Okay, thank you. I apologize for mispronouncing your name.
It's okay. I know it's a different name.
Okay, you're charged with one count of driving, fleeing, or attempting to elude a police officer, a second count of willful obstruction of a law enforcement officer, and a third charge of improper turn, all with the offense date of August the 6th, 2022. Pre-trial.
(2013) misdemeanor possession of marijuana, NOLO. August 12th, out of Decatur, obstruction. And that's open in DeKalb County. This is a third arrest. I don't have the driving history.
All right. ASG Johnson.
Your Honor, I didn't mean to interrupt, but Miss Pretrial just misspoke. This is my first arrest.
You're not to speak at this point.
I'm sorry, I asked the sheriff if she unmuted for me to speak.
Hold on, you have counsel to represent you, so defer to them so that you don't make any statements.
Yes, ma'am.
Okay, all right, ASG Johnson.
Yes, Your Honor. She has a pretty unique name, but I think I'm showing pretty much similar to pretrial. I'm showing a NOLO 2013 for marijuana and a willful obstruction open case in DeKalb. But going forward, I'm sorry.
The third arrest.
That's what I have as well.
Yeah,
I was just reading. Go ahead. What did you say?
No, I said it's a third arrest. We're not gonna go back and forth. We got the correct history.
Thank you, Mr. Howard. At the date of offense is August 6, 2022. The incident location is Interstate 20 at Hill Street. Your Honor, I believe she already has a $4,500 surety bond. We be asking that stay the same with $1,500 on each charge. For the facts, Your Honor, the officer observed the defendant make a left turn from behind him and then cutting him off. The officer conducted a traffic stop and the defendant refused to stop. The officer placed the defendant under arrest and the defendant resisted moving and twisting so that handcuffs would not be placed on her wrist. Your Honor, that's all the facts that I have for the court.
All right. PD Johnston.
Yes, Judge, we're asking for a signature bond on this case. Ms. Oko is employed by the City of Atlanta and has been for several years. She lives in Fulton County, has lived here since 2017. She does community service work with the March of Dimes. And she would be able to return to work if she was released, which is why we're asking for the signature bond so that she can continue working and that, she's doesn't get too behind on bills because of this incident. She also does have an active lawsuit out of DeKalb County against officers in DeKalb County. And because of sexual assault experiences she has had with officers there, and that it has contributed to the events we are discussing right now. And for that reason, without going into too much detail, we are asking for a signature bond.
All right, I am not inclined to grant a signature bond, but I will reduce the bond to 3,500 surety bond, 3,500 surety bond, no drugs, alcohol, or weapons while on bond. And I guess that is it, because there's no stay away and no victim. So unless there's not to be any contact with the officer, but I won't do that because that wasn't requested. So $3,500 surety bond and no drugs, alcohol, or weapons will be the ruling of the court.
You'll break that down, Judge?
Oh, I'm sorry, I forgot I have 3 charges. So that's 1,000, 1,000, what is it? Divide that by 3 for me. Or it's gonna be an odd number.
Yeah, it is.
So just make it 3,000, 1,000 on each case.
Okay,
That'll be a little simpler.
okay,
$3,000 surety bond, 1,000 on each charge.
okay, thank you.
All right, that will be the ruling of the court.
Thank you, Judge. I was wondering if I could ask a question about Mr. Jackson, if we could go back to that case regarding the stay away order.
Yes, Mr. Dennis Jackson.
Yes, that was position 8.
Uh-huh,
And the co-defendant case was position 9.
correct.
So Mr. Jackson resides at the 5 Livermore Street address, and I'm trying to inquire if there was a stay away issued for that address.
It's
I
my,
believe it was. Go ahead.
it's my understanding, Your Honor, that you did a stay away from her address. We didn't have her address, but you said to stay away from her and where she resides. That's what I wrote down in my notes.
Okay.
And then I think you asked for a one-time escort for him to go to her residence if he had any things at her residence.
Okay, but we didn't put the address.
We did not.
Okay, thank you.
Water, yeah, we did not.
Okay, thank you, Judge.
All right, very good. You're making me break my rule. I said I was not.
I know, I apologize.
All right, who do we have next, Deputy?
Position 1, Alan.
Okay. This is case number 22 CR 005395C. Ashley Allen, you're charged with 1 count of DUI less safe, 2nd count of failure to report striking a fixed object, both with the offense date of August 15, 2022. Pre-trial.
Second arrest, last was 2003. Abandonment of dangerous drugs, transactions, and drug-related objects prohibited. That's it.
All right. ASG Segura,
This case occurred yesterday, August the 15th, 2022, at the intersection of the intersection between House Way and House Road, Roswell. In this case, the defendant, while driving, struck a pedestrian crosswalk light, did not stop to make a report. The crosswalk light was on the right side of House Road, which, based on the collision, it fell onto the lanes, which ended up blocking traffic. When police was flagged down by witnesses, they made contact with the defendant, who saw that the defendant also struck a curb, lost the wheel before veering into incoming traffic. When officers made contact with the defendant, they noticed that she smelled of alcohol, had extremely unsteady legs, was swaying in place, and was unable to stand still. Alongside, they also noticed that she had slurred speech, and bloodshot eyes. When asked what happened, the defendant started talking about her family issues. When asked again as to what happened, the defendant said it was initially an opossum on the road and then switched it to a squirrel. Afterwards, the defendant was asked to retrieve her identification, so she tried to walk back into her vehicle. But also noted that she was slow and unsteady on her feet, and she was also leaning on the vehicle, which resulted in her falling forward and hitting her head on a door frame. Afterwards, the defendant was asked again to retrieve her driver's license, but instead to give the officer her car keys. And asked again to get her driver's license, she was able to provide it. At that point, when asked about where she came from, she said she came from a barn, and she said she had drank half a margarita. When officers asked her if she agreed to take several evaluations, she agreed. And in that process, it was shown that she was unable to retain balance and nearly fell over when she was trying to stand up. At that point, she was arrested. So because of this, the state is recommending a $7,000 surety bond, $5,000 for DUI, and $2,000 for striking a fixed object, with the conditions of no driving, and alcohol, drugs, and weapons without on charge. Your Honor, we know this is a false arrest. Even so, DUIs are serious cases, and this occurred yesterday at around 10 p.m. So not only was she drunk, she was driving drunk at night. And not only has she hit a pedestrian crosswalk, she was also a severe risk to drivers around here. Not only has her actions caused a lane to be blocked, but we're really lucky that she not hit anybody out of another vehicle or not person who might be in the road, and she was also a danger to herself. So because of this, we're asking for this surety bond. Thank you.
all right. Ms. Gant,
Thank you, Your Honor. Ms. Ashley Allen is 38 years old. She has been in the Atlanta, Georgia area since 1993. She has a fiance here along with a sister and a nephew, and she informs me that her parents passed away in 2020. Your Honor, Ms. Allen is about one semester away from earning a bachelor's degree in early childhood education. She studied at Kennesaw State, where she earned a 3.5 GPA. She is unemployed at this time. Her the last time she was employed was 2020 as caregiver to her mom. She denies the allegations and she is presumed innocent. My client's history is remote. This is what we heard about is an arrest from 2003. This is her first arrest. Again, she is presumed innocent. I am requesting a signature bond on Ms. Allen's behalf. And if Your Honor determines that she is ineligible, I would ask for a bond of no more than $1,500. That would be $1,000 for the DUI less safe and $500 for the driving hit and run. Thank you, Your Honor.
all right. I'm going to order a $5,000 surety bond, $3,000 on the DUI, and $2,000 on the striking fixed object. So it's a total of $5,000 surety bond. No drugs, alcohol, or weapons while on bond unless those prescribed to her. And of course, no driving unless she has a valid driver's license through DDS.
Thank you, Your Honor.
All right, that was this case.
Position 14, Smith.
Schmidt. This is 22 CR 005406G Robert Schmidt. You're charged with 1 count of simple battery family violence and a 2nd count of battery family violence and a 3rd count of cruelty to children in the 3rd degree, all with the offense date of August 15, 2022. Pretrial.
11 total. He got history out of Illinois, Arizona, and Hawaii. Last was 2012, domestic violence out of Arizona. It was dismissed. All its history. Oh, hold on. What's this? Last arrest in Hawaii. 2014. It says family abuse dismissed. 2009 harassment dismissed. 2006 family abuse. That was dismissed too. 2006 criminal damage to property dismissed. So everything you got dismissed.
Okay. All right, ASG Reed.
Thank you, Your Honor. The date of the offense was August 15th, 2022, and the location was 2661 Beeler, Beeler Road, Southwest Atlanta. And the victims of this case included his 14-year-old daughter with initials KK and his wife. I'll spell the first and last name, K-A, this is the first name, K-A-U-I-L-A-N-I, and her last name is spelled K-A-A-N-A-A-N-A. The facts on this case, Your Honor, the defendant and his wife, they've been married for 16 years and they have 3 children. KK is their oldest child and she's 14 years old, and they have 2 younger children that also live in the house. This altercation occurred over a cell phone. The defendant took his wife's cell phone and she grabbed it back. And while doing so, the defendant punched her in the face and she fell to the ground. He grabbed her up by the hair to pull her off the floor, and the officer did observe, after he got there, he observed there was rug burn and scratches on her arm. The 14-year-old daughter heard the commotion and she tried to intervene by jumping on the defendant. The defendant then punched her in the face. Now, the officer did say there were no visible markings on her face as a result of that. The officer spoke with the defendant at the scene, and he said this dispute's been ongoing since April and that he is in the process of leaving. The defendant admitted to the officer that he, quote, spanked his 14-year-old daughter for running into the room. And the officer asked why she ran in the room. And the defendant said, well, I was arguing with my wife. It's our understanding that our office has not made contact with the victims, because when we call their number that's provided, whoever answers hangs up. As pretrial mentioned, Judge, this is defendant's 5th arrest for domestic violence type charge, and all the previous cases he had were dismissed. But the state sees a serious concern about this defendant influencing victims, his wife and daughter, so that they refuse to prosecute. Here, Your Honor, appears to be a cycle domestic abuse with this defendant, and for that reason, the state is requesting a stay away and no further contact while out on bond. In terms of ties to the community, the defendant is a multi-state offender, even though, and most of his criminal history is in Hawaii, and he's also had arrests, as you've heard, from Illinois and Arizona. So his ties to Georgia are not that strong. So, Your Honor, we're asking for a total of $6,000 surety bond. That broken down would be $2,500 as it relates to count 1, simple battery, family violence. As it relates to count 2, it would be $3,000 for battery, family violence. And as it relates to count 3, cruelty to child in the 3rd degree, it would be $500. Thank you.
All right. PD Johnston.
Yes, Judge.
Ms.
Mr.
Johnson,
Sch-
can I speak before you, please?
No, sir, please let me speak first. Mr. Schmidt is employed. He is a machine maintenance technician, and he has been doing that for 6 years. He has also been in the Atlanta area since November of 2015. He has plans to move in with his sister upon release. We would ask your honor to allow him to return one time with law enforcement to retrieve his belongings from the family home, and then he can go and stay with his sister, which she also lives in Georgia, in Ackworth, Georgia. So he would be staying in the Georgia area. I also want to point out that all of these past arrests were dismissed. We would be asking for a signature bond on this case if possible. If not possible, we'd be asking for a $3,000 surety bond. And again, allow him to return with law enforcement to retrieve his belongings. And Mr. Schmidt, I don't advise you say anything. Please let me speak for you.
Ma'am, I think I need to make it clear that all the other domestic charges are with my younger brother who is bigger than me, not my wife.
Okay. Please, I don't think that's relevant right now. We've pointed out that they were all dismissed, and anything you say here can end up being used against you. Thank you, Judge.
Okay. All right, I'm going to order a surety bond in the amount of $6,000. First charge, $2,500, second charge, $3,000, third charge, $500, for a total of $6,000. I'm going to order a stay away from 2661 Beeler Road, Southwest in Atlanta. I'm going to order a one-time police escort to return to get any personal belongings Mr. Schmidt may have at that property. I'm going to order no further contact with his wife, no further contact with the minor KK. Please do not go back to that location, Mr. Schmidt. I'm gonna order no drugs, alcohol, or weapons while on bond, except for anything prescribed to him.
Your Honor, how am I supposed to post this bond? I have no way to get hold of my sister. She has all my property, my money. I can't post this bond.
Well,
I'll be terminated from my job if I can't get out.
You're gonna ask the jailer, the bondsman or someone to get in contact with her. Post your bond for you, but I am going to give you the surety bond.
There's no number though. I don't have a contact. That's what I'm saying. The arresting officer didn't allow me to retrieve my property, so I have no contact information. I have no money.
Okay, well, you'll come back on the calendar to be evaluated, but at this point, I'm going to do the $6,000 surety bond.
And this is all false pretense though. There was no physical altercation. I did not touch the.
Mr. Schmidt, if I could really quickly, like I explained earlier, today is not to determine guilt or to, go through all of the merits of the case. It's just for the judge to set bond, and she has set bond. Sorry, Judge.
Yeah, no problem. So if you go through a bonding company, it's 10 to 15%.
Position 4, Mr. Ellum. Come on, Mr. Ellum.
Judge, that was all of my cases I was handling today. May I be excused?
Yes, you may. Thank you.
Thank you.
Okay, this is 22 CR 005399F, Andre Elam. You're charged with one count of theft by shoplifting, offense date November the 6th, 2021. Pre-trial?
6 total. 2015 suspended license. 2015, another suspended license dismissed. 2018, suspended license, fleeing an officer. 2019, misdemeanor possession of marijuana conviction. 2021, misdemeanor theft by taking. We went to felony earlier. I think he got a $10,000 bond on that felony charge. That's it.
All right. ASG Segura.
This occurred on November the 6th, 2021 at a Sunoco gas station located at 52 Northwest Broad Street, Fairbairn. In this case, the defendant took beef jerky from that Sunoco and left without paying. Then less than 5 minutes later, he came back and took a can of beer. Because of this and due to his history, the state is recommending a $3,000 signature bond with the conditions of no alcohol, drugs, and weapons while on bond, and a stay away from that Sunoco gas station, again at 52 Northwest Broad Street, Fairbairn. Thank you.
All right. Ms. Gant?
Thank you, Your Honor. We are unopposed to the $3,000 signature bond through pretrial services. Mr. Elam is 27 years old. He has been in the Atlanta, Georgia area his entire life. He is the proud father of 2 sons, ages 6 and 1. Those children do live with him on weekends and he pays child support. He also is expecting another child. His girlfriend is pregnant at the moment, Your Honor. Mr. Elam completed high school. He also has a degree in criminal justice. He is currently employed at DHL and has been in that position since May of 2022. He is still within that 90-day probationary period. So he really needs to get back to work, Your Honor. My client denies the allegations. He informs me that he was unaware of this warrant. The date of this warrant, well, the date of the incident is, I believe, November 26, 2021. He tells me that he was working from 6 p.m. to 4:30 a.m. at Amazon. Your Honor, he told me that he did not even have a car to be in Fairburn, and he intends to prove that he was not at this location and that he is innocent. Your Honor, I am requesting a signature bond. The state has recommended one. The report that I received states that he is eligible for a signature bond as well, and we are unopposed to the stay away. Thank you, Your Honor.
All right. I will grant the $3,000 signature bond through the jail and a stay away from the Sunoco in Fairburn. No drugs, alcohol, or weapons while on bond, except for anything prescribed to you. And I guess that'll be it. 3,000 signature bond through jail.
Thank you, Your Honor.
Come on, her position 7, her.
Is number 6 still reset?
Oh, it's number 6 still reset, deputy? I did not know.
That's their Union City.
Oh, okay.
I'm sorry?
No, Your Honor, I can answer for that is my case. She's not reset, but we did request I did waive her appearance, Your Honor.
Oh, waiver of appearance. Okay.
She's at South Annex.
Gotcha. Okay. All right, position 7, 22 CR 005400Y. This is it Jamar Heard? You're charged with 1 count of criminal trespass. The offense date is August 15, 2022. Pre-trial?
Third arrest. Last arrest was last month. Suspended license. Before that was March. Misdemeanor possession of marijuana. Possession of drug-related objects that appears to be open. That's it.
All right. ASG Johnson.
Thank you, Your Honor. I will be asking for a 3,000 signature bond on this case and a stay away from the incident location. Just quickly, Your Honor, the date of the offense is August 15th, 2022. Location 2424 Piedmont Road, Northeast. The defendant pushed through the fare gates at the Martyr Lindbergh Station. An investigation stop was conducted by a Martyr police officer. It was found that the defendant had an active criminal trespass that was issued on June 9th, 2022. It was effective on July 9th, 2022, with an expiration date of September 7th, 2022. So he was arrested. But Your Honor, all I'm asking for is a 3,000 signature bond and a stay away.
And that stay away is from which station?
The Martyr, I believe he has a suspension from Martyr, period. So I would ask you to stay away from Martyr.
Okay. All right. Ms. Gant.
Thank you, Your Honor. Mr. Jamark Hurd is 20 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here. He completed high school. He also has 2 years of college where he studied computer science. He is currently employed, Advanced Pro Services. He has been in that position for 3.5 months, so he just completed his probationary period. He's anxious to get back to work. Mr. Hurd denies the allegations. He is presumed innocent, and I am unopposed to the signature bond as proposed by the state, nor am I opposed to the stay away from MARTA. Thank you, Your Honor.
All right. I'm going to order a $3,000 signature bond through the jail. I'm going to order a stay away from all MARTA. Mr. Hurd, when you get out, you need to find other means of transportation, Uber, Lyft, or some other ride share programs. You cannot go back to MARTA. You cannot get on MARTA. You have a ban from all MARTA. And I am putting in this order that you will stay away, totally stay away from MARTA, okay?
Okay.
Judge, is it through the jail or through pretrial?
To jail. No drugs, alcohol, or weapons while on bond. So it's a $3,000 signature bond for jail. All right?
Thank you, Your Honor.
Yeah, I have like one question.
Mr. Please don't speak. I'll give you a call to answer any questions for you, okay?
All right. Position 2, Bradford.
Your Honor, I did request a breakout for position 2.
Okay.
And also a breakout I did not announce to the court, but I placed in the chat a breakout for position 10 as well.
Okay. And Mr. Segura, is Miss Falk still with you? Or who needs to go on the breakout with you?
Yes, Your Honor.
Okay.
We're ready to go to the breakout.
All right, thank you.
Yeah, you gonna talk about both of them in the breakout?
These are co-defendant cases? Both
No, but I
No,
just
Your
figured since
Honor.
y'all were going.
Well, I was going to say, I don't know if Mr. Howard would like to put their histories on the record before we go to the breakout, just to make sure we're fully informed.
Yes.
Who we doing first? Bradford? Second arrest for Bradford. Last arrest was back in May. Dissemination of information related to terrorist threats. That's open in Superior Court, 22 CP 208967. So this is his second arrest. Open case. McCoy. This is his 10th arrest. Last was back in October for trespass. That's open 21 CR 005 583Y. 2018 battery Nolo. 2014 burglary first degree. I gotta look up that disposition. 2011 armed robbery, possession of a knife or a firearm during a commission, dismissed. 2010 marijuana possession. That's it.
All right, thank you for that, making that a little easier. All right, now you can put us in the breakout. Anybody with you, Ms. Garrett?
No, Your Honor.
Okay.
Who all needs to be in the breakout room, Judge?
Oh, yes. Hi, Mr. Jordan. Mr. Segura, Falk, and Gant.
And Judge, I'm
as well
with position 10.
Yes, okay. And Ms. ASG Reed, which case are you on?
Position 10, McCoy.
Okay. You want to come in for for both, or just go ahead and put her in?
Yeah, that'll work.
You can do it at one time, Mr. Jordan. Basically, all of us left who are on the calendar. And who's Tiffany Johnson?
ASG Johnson. She's not on either one of these cases, but if you want to send her into the breakout so she can observe, that would be fine as well.
Okay. I was just making sure it wasn't a victim. All right, who do we have, deputy? Courtroom 2?
Yes, ma'am. Yo. Yes, ma'am.
All right, who do we have?
This is still Mr. Bradford.
Okay, Mr. Bradford, your bond on your case is a $3,500 surety bond. And you are to have no further contact with the victim, Brianna Gordon. And if she needs to come to get any of her personal items, she will have a police escort to remove those from the location. No drugs, alcohol, or weapons while on bond. And was there anything else, Bridgewater, that I had on there?
The provision about selling or destroying or removing the property.
And thank you. In the interim, before Ms. Gordon is able to get there with her police escort to retrieve her items, you are not to sell, destroy, or give away any of her personal belongings. You can box them up somewhere, but you cannot destroy, give away, or sell any of her items till she gets back there to get them with the police escort. Is that clear? Okay. All right. Thank you.
Thank you, Your Honor.
And then we also discussed 10. Do you have 10, deputy, which is Mr. McCoy?
Your Honor, I waived his appearance.
Oh, okay. Sorry about that.
Houston, come on, Mr. Houston.
I'm sorry.
Before we go to number 5, Mr. Hurd had a question. It was just a question about this case. It wasn't about the fact of the case. He just wanted to ask one question.
No. I don't want the facts of the case discussed.
He's not talking about the facts. He has a question.
About his bond.
I do not want him speaking. I will call him. Please hold him in the courtroom.
Okay, thank you.
I do apologize, Your Honor.
So this is position 5, Mr. Houston.
Yes, this is position 5.
Okay. This Paris Houston 22 CR 005397E. Certain acts on bus rail station prohibited and criminal trespass. Each of those counts has an offense date of August 15, 2022. Pre-trial.
Third arrest. Hold on. 1, 2. Yeah, third adult arrest. Last arrest was 2017 marijuana possession. Pled no load of simple battery in 2010. That's it.
All right, Mr. Segura.
This case occurred yesterday, August 15th, 2022, at a 5-Point Motor Station at 30 Alabama Street, Atlanta. In this case, the defendant was on a motor train going between emergency doors on that train, but having no emergency. Afterwards, he was told by motor police to leave the station, but he refused, and therefore he was arrested. For this case, the state's recommendation is a $4,000 signature bond, a $4,000 for $2,000 for each count, with the conditions of no alcohol, drugs, and weapons, and a stay away from that motor station at 30 Alabama Street, Atlanta. Thank you.
All right, Ms. Gant.
We are unopposed to the signature bond, Your Honor. Mr. Houston is 30 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here. He completed high school. He also studied automotive collision repair at Atlanta Tech. He is currently employed at Cookout as a manager. He has been in that position for 10 years. He denies the allegations. And again, I am requesting a signature bond as he is recommended, and we are unopposed to the stay away. Thank you, Your Honor.
All right. Mr. Houston, I'm going to order this $4,000 signature bond through the jail. And you are to stay away from the 5 Points MARTA station while you're on bond. And remember, they've got all the technology. If you go back there, you will be arrested again. So you're to stay away from the 5 Points MARTA station. I'm not gonna say all MARTA yet because I don't know if you have a ban yet. But if you find out later that you're banned from MARTA, then you need to definitely stay away from all MARTA, depending on what their documentation or their suspension says. No drugs, alcohol, or weapons while on bond unless anything prescribed to you. All right?
Yes, ma'am.
Thank you, Your Honor.
Good luck to
Is that
you.
two- is that 2 and 2? Or how you breaking it down?
Yes, 2 and 2. I'm sorry, yes, 2,000 each.
Thank you, Judge.
Signature bond through the jail.
What number can I call you at, Ms. Grant?
I'm sorry, I will give you a call. You gave me your number. I'll give you a call at your aunt's number.
I said, what number can I call you at for Mr. Hurd?
Oh, I'm sorry. The number that the jail uses,
Good.
All right, is there something you want to put in the chat if he doesn't have it?
What was the bond amount for number 10 when y'all was in the breakout?
Oh, I'm sorry. Hold on. 10, the breakout, $1,000 surety bond.
Okay.
And Your Honor, I understand that they may need to take him back. May I just take this call?
Yeah.
To?
Okay, yes.
Thank you, Your Honor.
Uh-huh. She's gonna take the call, deputy.
Are we
So,
done?
Position number 6.
Yeah, Howard. What we gonna do with Howard?
Waived appearance, are we having that? That may be Ms. Gant, soon she gets off the call.
It is, Your Honor.
Okay. So hold for a second. Mr. Toussaint.
Judge, were you able to get some information that we talked about earlier for me?
Your Honor.
Okay, she's back. Okay.
Yes.
Regarding Mr. Hurd, he tells me, this is position number 7. He tells me that his personal belongings are being held at the Candler Metro Station. So I'm requesting a one-time law enforcement escort so he can retrieve whatever belongings may be there.
Okay. And what station is that?
He said it's the Candler Metro Station.
Campbell. Okay. So we can add that,
okay,
Ms. Bridgewater to position 7.
Okay.
One-time police escort to the Candler Park Station to retrieve any personal items. But it must be with a police escort.
Thank you, Your Honor.
Thank you. All right, are we on position 6? I think we're finished with you at the jail, huh?
Yes, ma'am, that's everybody that we have.
All right, have a good afternoon.
You too, ma'am.
All right, thank you. All right, this is 22 CR 0053774C. Shaquella Howard, 1 count of criminal trespass and a 2nd count of disorderly conduct. Appearance has been waived. The offense date is April the 4th, 2022.
She got 70 total, 70.
70, okay.
Yes. Last arrest was in June for ag assault. It says assault, a federal authority. So she's on probation for that by the feds. 2019 fade to appeal, 2014 fade to appeal. Probation violation 2015, 17, and 2021. She went to felony yesterday. They gave her no bond for this ag assault. So
I just want to come in tomorrow.
that's it, Judge. I'll leave it at that. Because it's 17 arrests, so between Georgia and Alabama.
Thank you, Bogle.
Courtroom 2, you're not muted. Thank you. All right. Okay. ASG Reed.
Thank you, Your Honor. The location where this occurred was 111 Boulevard Avenue, Northeast Atlanta, and it's a Chevron gas station. The defendant was arrested on August 14th for aggravated assault after spraying pepper spray in the employee's face at the Chevron at the 180 Ponce de Leon Avenue. But for this case, it occurred at the 111 Boulevard Avenue, and she had been recognized from past experience for stealing merchandise from the Chevron, and that's why the lady on the 14th was calling the police. So the police arrived, and she had an outstanding warrant for the charges that occurred April 4th of 2022, and that's for this case. She's being charged with disorderly conduct because she used profane language towards the staff and caused a scene in front of the customers, including spitting on the business windows after being asked to leave. And the defendant's being charged with criminal trespass because she continues to come back to the property after she's been asked to leave. The state believes that the defendant is at high risk of reoffending because of her previous record and due to the subsequent arrest in August 14th. The defendant does not have strong ties to this community. Most of her past history, we understand, is out of Alabama. Currently, she does have a $1,500 surety bond on each count, and the state's recommendation is a $1,000 surety bond total, and that relates to for count 1, $500 surety bond, and count 2, $500 surety bond. And as pretrial mentioned, the case for the aggravated assault charge, the 22 CP 211482, that bond hearing was yesterday, and she did not receive a bond. Thank you.
All right, Ms. Gant.
Thank you, Your Honor. Ms. Shanquella Howard is 33 years old. She informs me that she's been in the Atlanta, Georgia area her entire life. She does not have any family to help her to post or pay anything toward bond. And of course, we know that she's not a flight risk, being that she received no bond in the ag assault charge, for which she's presumed innocent in that case as well as this case. She denies the allegations. Ms. Howard completed high school, and at this time, Your Honor, she is unemployed. I am asking this court to grant a signature bond on Ms. Howard's behalf, and if Your Honor determines that she is ineligible, then I would ask for a bond of no more than $100 for each count, as she will not be able to bond out to pay anything, Your Honor. Thank you.
And Your Honor, if I may, I did forget to say, we are asking for a stay away from the Chevron location and no drugs and alcohol while out on bond. And the Chevron location for this case is the 111 Boulevard Avenue, Northeast Atlanta. Thanks.
And the defense is unopposed to the stay away.
All right. I'm going to order the $1,000 surety bond, which is $500 on each. I'm going to order a stay away from the Chevron at 111 Boulevard Avenue Northeast. No drugs, alcohol, or weapons while on bond.
Thank you, Your Honor.
Thank you.
All right, thank you all. So is that our last case?
Yes, it is. Yes, it is.
Don't be so quick to say that.
Okay, so we're ready to go over the calendar?
We are.
Okay, so here we go. Once again, the reset date for the SAP calendar is going to be August the 30th. Position number 1 is going to the SAP calendar with a $5,000 total good bond. Position 2 is going to the SAP calendar with a $3,500 good bond. Position 3, the SAP calendar with a $5,000 good bond. Position 4 is being reset further notice with a $3,000 SOB through the jail. Position 5 reset further notice with a $4,000 total SOB through the jail. Position 6 going to the SAP calendar with a total $1,000 good bond. Position 7, reset further notice with a $3,000 SOB through the jail. Position 8, reset further notice with a $1,000 SOB through the jail. Position 9, reset further notice with a $2,000 SOB through pretrial per judge. Position 10, reset to the SAP calendar with a $1,000 good bond. And by the way, we're gonna put a companion case on that calendar with this case. Position 11, reset to the SAP calendar with a $1,000 good bond. Position 12, going to the SAP calendar with a total $3,000 good bond. Position 13, reset further notice with a $5,000 SOB through pretrial. Position 14, reset to the SAP calendar with a $6,000 total good bond. And position 15, reset further notice with a $4,000 SOB through pretrial. Any questions, comments?
12 was 3,500 or 3,000?
12 was 3,000. The judge changed it to $1,000 each charge. Okay? Are we
All right,
all
y'all.
good?
Yep, I'm good.
You're good?
Yes.
All right, if pretrial says we're good, we're good. And we'll see you all next time.
Okay,
Your
Judge.
Everybody have a good afternoon.
You too.
Your Honor,
Yes.
I just want to say, I haven't had a chance to really introduce myself to you, but I found out you were a Fiskite, so I have to say hello.
You're a Fiskite. Wow, there's not as many of us around. What did you say, pretrial? Oh, I thought you just said bye. Well, welcome. I won't tell you what year I am. You can look that up, but I'm sure it was many, many years before you. So nice to meet you. Yeah, because I saw in there, I was like, who the heck is Tiffany Johnson? I get confused sometimes just getting them known. I'm like, if you don't put it on there, my brain is in another zone, and I thought it was a victim. So I apologize for not remembering your name. But
I'll make sure to keep putting it on there.
yeah, well, that's okay. I understand. And then how long have you been at the solicitor's office?
I just started.
Just started. Okay. Well, welcome aboard. It is never a dull moment, is it, Ms. Camp?
Never.
And today was a smaller calendar, so I thought we were going to get through quicker. And that doesn't always mean that either, because, you know, depending on what the issues are, sometimes shorter calendars take longer. And
Like a box of chocolates.
Exactly, and a box of chocolates. That is a very good one. Well, nice to meet you, and good to meet you, Fiskite.
Likewise.
All right, you all have a good afternoon. All right, bye-bye.